Get started. This is time set for oral argument. In our case, Croner versus DDD, UB19-0063. Council, we have reviewed your filings. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you do present oral argument. Each side has 20 minutes. Ms. Hoffmeyer, if you wish to reserve a portion of that time for rebuttal, please feel free to do so, but you'll need to keep track of your own time. I will do kind of, and let me grab actually a clock, do kind of a rough timekeeping as well. When we're able to hold these in our courtroom, we have this delightful clock system at the podium. We're not encumbered with that today, so it'll be a little more approximate, but please do keep track of your time, and I will do so as well. The proceedings are being recorded. Please keep that in mind, and we'd encourage you to, when you present, start with your name and the party that you represent. And with that, Ms. Hoffmeyer, you may proceed.
Thank you, Judge. So I've just got my own timer going. Good morning, Your Honors. May it please the court, my name is Adrian Hoffmeyer, and I'm representing Alex Croner. He's the appellant today. Alex is a now 8-year-old boy with autism who about 2.5 years ago, around his 6th birthday, received a notification from the department that it intends to terminate his disability benefits. So Alex's autism is quite severe. He can't dress himself, wash himself, brush his teeth on his own. He still wears diapers. To quote his occupational therapist, he still, quote, poops his pants. And you can understand about 30% of what he says. The primary issues before the court today are both legal issues. And the first one I don't actually intend to spend much time on unless the court feels differently, and that's the burden of proof issue. The question is, who has the burden of proof at these hearings where a child who has qualified and has been receiving DDD benefits turns 6?
I think that's an important issue. Do you think there's a more important issue in this case?
Well, Judge, I think that the case of AW v. ADES, the recent case that has come out of Division 1 of the Court of Appeals, is now determinative. The department, in response in our briefs, relied on the fact that it was subject to a petition for review to the Supreme Court at the time, and our Supreme Court has denied that petition. And so the way I read it, I believe that AW has established that the burden will be on the department. But if you want me to go into it and go through the arguments, I can. Also, the arguments the department made in AW are the identical arguments they're making here. They've taken the position that when a child turns 6, it's a new application, it's not a termination. And I think that AW clearly established that, and AW was on all fours in that sense. It was a 6-year-old with autism, so-called aging out. And the court...
So this is Joe Cal, and I'm asking, does the issue of the burden of proof determine whether you succeed or not? I mean, can you succeed even if you had the burden of proof?
Judge, yes, and for 2 reasons. The one is, and I know that the court doesn't like to dive into factual issues, but I did go into a fair amount of detail in our brief that our record is fairly thorough, and that even on this record, you can see that the documentation provided by Alex through his grandfather satisfies the burden of showing that Alex has certainly at least 3 of these, the 7 major life activities that are set out in the statute, that he has at least 3 of them. But more importantly, and the legal issue that I kind of anticipated you'd want me to go into more is this issue of due notice, that the only government witness was Jennifer Gray. She's their in-house document reviewer. She took a look at the reams of documents provided by Alex and wrote them all off and said they didn't satisfy her standards. She took into account nothing that Alex submitted to substantiate the term SFL, the significant functional limitations. And so substantial functional limitation, SFL. So she took into account his treating physician is a specialist. And there were 8 documents from him. Dr. Mark Ruggiero, he's a board-certified developmental and behavioral pediatrician. He specializes in autism. She refused to take into account any of those documents that were submitted by him. And 3 of them were around the time of the hearing. They were very current. And she blew them off and said, oh, it doesn't meet our standard. And if you go and look at that regulation and see what departments, what documents the department puts us on notice they'll accept, it's nothing like what Jennifer Gray said during the hearing. And so we believe, number one, that this due process issue is as important as the burden issue, and that either way on the burden issue, in our particular case, and I haven't seen another case that's on all fours in this sense, is just disregarding the documents we submitted because they weren't good enough for her. She expected Alex's granddad to guess that she literally said, quote, and I'm kind of diving into this argument straight away. I don't know, Judge, if I've answered your question.
Well, yes, but a second question I have is, if Dr. Gray didn't consider those documents or that evidence, did you make the argument to the board on review that this evidence should have been considered, and what did the board do in response to your argument?
So when the appeal, let me just make sure I understand your argument correctly. Are you trying to assess whether this argument was put to the board?
Yes.
So, you know, the appeal, the notice of appeal, so to speak, that goes from the ALJ to the appeals board is a one-liner, right? It was Alex's grandfather. There's no attorney involved at the time. He is at the end of the ALJ's decision, and he's advised, if you don't like it, you can take this to the appeals board, which he did. And there were essentially no arguments that he made in that document that he submitted to the appeals board. But I don't know that he needed to. I don't know that there's certainly no briefing at all that goes to the appeals board. Nobody submits any arguments to the appeals board. It just reviews the record from the ALJ, and then
did the board say anything about the evidence that you're pointing to now?
No, both the ALJ and the board accepted Jennifer Gray's assessment that our documents were insufficient.
Counsel, let me ask you to return to the burden of proof issue. If, as you say, AW resolved that issue, and I'm not sure I read AW that way, but is it your position that the board, the ALJ and the board here, followed the burden of proof allocated in AW, or that they did something different?
Well, the ALJ in his ruling acknowledged, because it wasn't in dispute, because at the time the department agreed that the burden's on the department because this is a termination of services. In the ALJ's ruling, he says this is a change in the status quo, therefore it's a termination, therefore the burden's on the board. That's exactly the wording that the department used in their pre-hearing statement. So this was not an issue at the ALJ, the burden at all. It then goes to the appeals board. There's no briefing. Nobody has, the department certainly didn't change their position there. But of its own accord, here we've got the appeals board coming up with a new standard, where the appeals board set out, it shifted the burden to Alex.
And is that consistent with how you read AW, or different than that?
No, well, the test that the appeals board implemented in its ruling is completely different to the test that the department is arguing for here. And in its briefing, the department kind of sidesteps that and says, yes, we agree with the appeals board, they got the burden right, and then says that it's because it's based on ARS 36560, which is not a section that the appeals board mentioned at all. The appeals board test was the burden starts off on the department. If there's a significant event, it shifts to the applicant, or not even the applicant, to the party, to the child turning 6. And then he said, in this particular case, just turning 6 is that significant event, and the department only needs to prove that he's turned 6, and therefore the burden's on the child, on Alex. So that's not a test we've seen anywhere before, and it's certainly not a test the department is promoting now.
And in fact, under AW, I'm not sure that AW really goes as far as you suggest, because in AW the burden wasn't really at issue, right? I mean, the department adopted a different burden than or at least the ALJ adopted a different burden than in this case, and AW didn't have a chance to confront that directly. I'm wondering if you think that there are any statutory provisions that we should look at in addition to the Arizona Administrative Code that might bear on burden of proof.
So, Judge, I think it is. First of all, the AW ALJ that was being appealed, or it may have been the appeals board, had agreed that the burden was on the department. So in AW, there was no attempt by an appellant to overturn a ruling. So I think that is one distinction. You're right.
Yeah.
And my understanding is that the court asked for briefing on the issue of burden. There's also very little case law cited by the court in AW. AW says, we don't feel that the department has given us sufficient of an argument to overturn. So I do agree with you. AW may not go as far as I would hope it would go. I do think that the court showed its inclination that it was not convinced that the burden should rest on the child who turns 6.
Sure.
But to answer your question,
yes, we're writing on a blank slate today.
Okay. So I've got some regulations, but I'm going to be very specific because you asked only for statutes. We've got the department relies solely on ARS 36560C. That is quite clearly a section that applies to a new application only. So that section does not help us here. ARS 36566 is a contrasting statute. And that says that when the child turns 18, they automatically terminated. And if they want to continue receiving benefits, it is a new application. For a child turning 6, that section is absent, that provision. And I think that we can read into that it is therefore different. And it's not a new application.
You skipped over the statute I was kind of interested in discussing, which is 36565.
Okay.
Which requires the periodic review and determination of eligibility.
Judge, may I pull that one up so that I can answer intelligently? Sorry, I should have had it. I'm looking at my second screen here.
Perhaps more intelligently than it was asked.
This is taking forever. Okay, so maybe there's another way I can get at this. So that's ARS 36. This is the one joy of doing this from your computer, from your desk. Sorry, Judge, it was 5?
565.
565.
And that to me seems like it sheds some light on this dispute. So I want to ask both sides about it.
So, right, okay, I remember this section. So the department has an obligation to basically check in every 6 months with a child with developmental disability. And
it seems that the department also has an obligation to make some sort of determination when it does so.
Right, and I'm looking in subsection A, the department also shall recommend to any person in charge programs and services. Right. Yes, so I'm sorry that I did skip over this one because this is a section that seems to be, together with the regulations, place a burden on the department to be very actively involved in the treatment of children with developmental disabilities. You know, this is read together with the regulation that we cite to a lot, which is the Regulation R6-6-601, where the department is obliged to appoint a case manager. And then the eligibility manual refers to a support coordinator. I'm also the way that these rules and the statute are written, they're not adversarial. They seem to me to be designed to be very much in favor of helping families, to make sure that they're getting the right services. And what my understanding also is that in the past, the department actually was the ones that paid for this testing. Any testing that was done to see whether a child qualified for services, the department was so actively involved that they actually paid for some of the testing. And I'm led to believe that about 5 years ago that stopped. And it's not because the regulations have changed. And what we found, certainly in our case with Alex, is that it's become extremely adversarial. No help is given to the grandfather as he's trying to put together these documents. And then the department just simply sits back, rubs their hands and says, well, you didn't give us good enough documents, which really is what is quite unique about this case. There's the burden issue, but even without the burden issue, he told us, I mean, not he, she, Jennifer Gray, repeated again and again in 3 hours of testimony in front of the ALJ that our documents weren't good enough. They didn't meet the regulation. So I'm kind of, I've hit my 15 minutes. I would like to leave, I think, is anybody else's timer? I would like to leave some in rebuttal.
Yep, very well. Very
yeah. Well. Is there anything more on that right now?
Judge Swan, Judge Howe, anything else?
No, thank you.
Very well, thank you.
Okay, so Judge, what time do I have for rebuttal according to your timer?
4 minutes.
Okay, perfect. Thank you. I'd like that.
Thank you. Ms. Folgert.
Thank you, Your Honor. May it please the court, my name is Joanne Falgett, and I'm representing the Arizona Department of Economic Security and its Developmental Disabilities Division in this appeal. Seems as if the court is most interested in the burden of proof issue, and I would love to address that a little bit. In ARS section 36-560C, as the court has already recognized, does provide that a person shall not receive services unless proof of the requirements in section 36-559 has been provided. 36-559 is the one that provides two different ways to provide proof. One way is that a person can be an infant, which in 36-551-19, the parallel statute defining developmental disability refers to that as a child under 6. So one can be an infant or child under 6, and as a result of tests performed, there is a, quote, strongly demonstrated potential that the infant has a developmental disability. The second way to qualify is to be a person with a developmental disability and provide medical and psychological documentation of such developmental disability utilizing tests which are culturally appropriate and valid. So in this case, Alex initially qualified for services under that is an infant or child under 6 provision, based on being what we like to call at risk. In other words, there's that strongly demonstrated potential that he might develop a developmental disability. He was not diagnosed as having a developmental disability, was not accepted into the program having proven that he had a developmental disability, but merely under that at risk section. So when Alex turned 6,
well, counsel, do you dispute that he has autism?
No, there's no dispute that he has autism. But the second
developmental disability, right?
That is a developmental disability. But the second part of that, in order to be eligible, so the statute defining developmental disability says it means either that strongly demonstrated potential, okay, that's what he initially qualified under, or has a developmental disability that is attributable to cognitive disability, cerebral palsy, epilepsy, or in this case, autism. B has to be manifested before the age of 18. C has to be likely to continue indefinitely. Okay, all three of those have not been disputed, but it's 36-551-19D, the definition of developmental disability, requires that it must result in substantial functional limitations in 3 or more areas of major life activity that are listed in the statute. And that's where the dispute in this case lies. Alex has never demonstrated that he has those substantial functional limitations.
That's where the factual dispute lies, but let's come back to the legal issue that we're here to discuss, which is the burden of proof. I'm unaware of any authority apart from the musings of your client that suggests that this McDonnell Douglas-like burden of proof that it created has any rooting in the law. Can you correct me?
Sure. And again, because the department is not allowed to provide these services until the person under 36-559A has provided the proof that he's eligible, and 36-559D, the department shall determine.
There's no case in Arizona history upholding this novel burden of proof, this shifting burden of proof. I understand how you might try to justify it under 559, but sitting here in May of 2020, it seems odd that we're just now figuring this out.
So the board had cited the Harvest versus Craig case, 195 Arizona 521, that talks about factors to consider regarding the burden of proof. And again, this comes down to, it is sort of a novel situation because of the interplay between the statutes and the burden of proof. The person is required to prove eligibility or they're not entitled to receive services. But here, the standards for eligibility change when the child turns 6. And so I think the board correctly recognized that to terminate the benefits the child had been eligible for. So suppose Alex was still under 6 and the department wanted to terminate benefits, then of course it would bear the burden to prove that something had changed. In that case, if Alex was still under 6, would need to prove that he was no longer at risk for developing a developmental disability, or that he simply did not.
Under 565, doesn't it have a semi-annual obligation to gather information and make determinations regardless of Alex's turning 6?
Certainly. And so but my point is that if at any time before he turned 6, the department had determined that he was no longer eligible under that at-risk standard, it would have borne the burden of proof to terminate. When Alex turns 6, however, then it's a pretty easy burden to prove that he no longer qualifies for those services in the at-risk category.
Let me ask you though, you're assuming that this this sort of split burden that Judge Swan was asking about has a basis in law. Is it your argument is it does? Is that based, where do we find that in statute, or is that something that Harvest v. Craig, the statute is silent and we look to secondary statutory interpretation like Harvest v. Craig, which it seems to me is what the board did?
So yes, the board did rely on that Harvest v. Craig case for those factors to consider regarding who should bear the burden of proof. And it did agree that to terminate services, the department bears the burden of proof. But the thing is, suppose we just had a statute that said children under 6 are eligible for services and they meet these criteria, they are eligible, and we found them eligible, and then the child turns 6, they're no longer eligible, right? There would be no question, if there was no other statute providing additional services beyond the age of 6, there would be no question that ADES could come in and say, hey, the child turned 6, they're no longer eligible, therefore we have borne our burden to prove that they are not eligible for services. Okay, now we have a second statute that says, but if the child is any age under 18, they can also be eligible for services if they prove A, B, C, and D.
Well, but
so now they have
your point with that is if they prove, and what we're struggling with is the predecessor to that inquiry. Where and let me better understand your argument on the allocation of burden of proof. Is it your client's argument that that comes from statute, or that the statute's silent and we need to look to Harvest v. Craig?
So both, really. The statute doesn't say the words, the burden of proof is X, but the statute does say, 36-559A says a person with a developmental disability is eligible to apply for the programs if the person meets these criteria, one of which is that they have to provide the medical and psychological documentation. In other words, they have to prove that they have the disability. So that, I think, is a pretty strong indicator that the statute requires the person to come in and prove that they're eligible.
But again, I want to let me follow up a little bit on that. It seems like either the statute allocates it or the statute's silent, and then we go to Harvest v. Craig. which of those is your position?
So again, it's going to depend, and I think that the board actually got it right in the sense that any person walking into DDD initially and wanting to become eligible for services must prove, they have the burden to prove that they're eligible for those services. If DDD...
You're putting that in the active voice where the statute is written in the passive. The statute is talking about whether the evidence demonstrates, not who must demonstrate it. And every time you describe it, you just insert the burden of proof as if it's a foregone conclusion. Where do you get that if they prove part, as opposed to if it is proven?
Okay, I guess I'm just reading the statute that says a person with a developmental disability is eligible to apply for the services if the person is a person with a developmental disability and provides medical and psychological documentation of such developmental disability utilizing tests, yada, yada. So that sounds to me like it's saying that person.
Well, but the words of the statute don't allocate the burden of proof. So don't we? Isn't your argument that we apply the factors in the Harvest case?
If the court believes that the statute is unclear, then yes, you could apply the factors in the Harvest case. And
a question I had about this is this, does the department view this as applying for services or a determination whether the services should be terminated or not? And does that affect the burden of proof?
So I think that the board got it right on this as well. If the board or if the department were seeking to terminate services and there had been no change in circumstances, Alex was still under 6, for example, then yes, the department would have the burden to terminate because they're the ones seeking to change the status quo, and it would be fair to place that burden on the person seeking to change the status quo. But here, they have demonstrated that circumstances have substantially changed. Alex turned 6, no longer meets the criteria for eligibility that he initially qualified under. And so now we have to look again and see, does he still qualify?
Well, Council, if there had been no movement to terminate services, would Alex still be receiving services even though he's over 6?
So basically, the department does continue to provide services until they are properly terminated. So eventually...
Well, so it's not a new, it's not practically a new application. It's whether the services should be terminated or not. So isn't the department moving to change the status quo?
Well, it is, but and again, under the Harvest v. Craig factors and under the board's analysis, which I think was correct. So to terminate services, the board has to show that he's no longer eligible. And by showing that he's no longer under 6, then he is no longer eligible under this criteria where he initially qualified. So now we have a new set of criteria that apply for children over 6, and nobody has ever demonstrated eligibility under that statute. And so again, the board noted the factors and said, you know, it's not fair to place the burden of proof on the department to try to prove that he's not eligible when the client is the person in charge of the ability to get all these tests and take them and provide the evidence if they have it. And so the burden then goes to that person as it would under an initial application to prove.
Let me ask you, with respect to gathering the information, because you just mentioned that, isn't that the obligation of a DDD case manager by regulation?
Okay, so it's not their obligation to do everything. The regulation says the case manager shall assist the client in all aspects, and so they do. Recommend to them tests to get, help them find service providers if they need it, whatever. But it's not the department's obligation to actually provide every test or to handhold the person and take them and make them get the test. And
who is Alex's case manager?
I don't know that information off the top of my head.
I'm not sure it's clear in the record.
So, and I would suggest that the reason it's not clear in the record is because nobody ever raised this issue until this appeal. So the department didn't have an opportunity to present any evidence to the ALJ or the board, and nor did Alex present any evidence regarding.
Back to my pet statute, but the department should have been complying with 565 all along, right? And that should have generated records of evidence that it gathered, determinations it made, and who made them. It should just be in the file.
So again, up until age 6, Alex was receiving services for the at-risk. Nobody was ever disputing that he wasn't at risk. And again, there may be stuff that is in the file that it didn't make it to the record before the administrative law judge, because typically people bring in stuff that is relevant. So again, the nobody raised
from DDD's perspective, this caseworker's file or case manager's file, wouldn't that be relevant?
Well, not necessarily. If nobody's disputing that the case manager did the job she was supposed to do, then
no,
that
but isn't it the documents and the testing and the other information that the case manager helps facilitate that's really relevant?
So, and there are plenty of documents, whatever documents are in the file. So, I mean, that to the extent that there are documents in the file, that is some evidence that the case manager did her job and facilitated and assisted and prompted Alex to provide whatever evidence he had or to get other evidence.
But Dr. Gray indicated that that wasn't good enough.
Right. And also, though, I think if you look at the record closely, you'll see throughout this case, Dr. Gray, the ALJ at the pre-hearing conference, DDD all along has been saying, here are the tests that you need. In the administrative decision, it had a long attachment to it with all the different SFLs, substantial functional limitations, and all the ways that you can prove that, the tests that DES thinks are the most useful for proving those things. But Alex didn't go get those.
That's the final agency action, right? Denying benefits. Doesn't that come a little late in the day?
Actually, that's the initial notice, which is then subject to appeal. That's the notice that is subject to appeal. That's the initial notice. Here's our decision.
I'm sorry. I thought I heard you saying that was the appeals board that did that.
No, so you have the administrative,
then.
yeah, the administrative decision. The very first thing that gets issued that has any kind of force is this administrative decision. And in that decision, Dr. Gray had reviewed the entire file and went through everything and said, okay, the records that are here are not adequate. Here is what you need to get in order to prove it, with the attachments on that administrative decision. So then we go forward and, he asked for a hearing before the ALJ. They have a pre-hearing conference. The ALJ says, okay, the thing that's at issue is these substantial functional limitations. Sounds to me like you're going to need that Vineland or that ABAS test in order to prove these things. We're going to set this hearing out till September to give you an opportunity to get that information so we can consider it here. He didn't do it. Then
again, let me just ask, there's no indication that the case manager was involved at any point after that information was shared.
And there's no indication that she wasn't either, because nobody raised this as an issue. And I would point out that even the appeals board, under ARS section, shoot, where did I had that? 23-672, the appeals board can even take additional evidence. So if he had even raised this issue in the petition for review to the appeals board could have considered this issue and taken testimony about what the case manager did or didn't do. But this was not raised as an issue. And under 41-1993, this issue about whether the case manager did or did not provide information or assistance appropriately is not appropriate for appeal, because it wasn't raised in the appeal application to the board.
It seems a shame, honestly, that we're arguing over whether the documents were sufficient or not, and not whether the circumstances were such that services should or shouldn't have been provided.
Well, so the ALJ and the board both considered the evidence regarding whether the services should or shouldn't have been provided. The ALJ did allocate the burden of proof to the department and found that Alex only met the criteria under one of those major life activity areas. The board...
Well, I'm sorry, Principal, that's because not that the evidence didn't prove anything, but that the documentation that was provided was not sufficient. That's a different determination.
Actually,
it seems to me.
If you read through the hearing, Dr. Gray addressed all of that. She talked about, she didn't just say these tests are insufficient, therefore no. She actually went through all of the documentation and she said, okay, I see here that this person has expressed this opinion, but they haven't provided any facts to base that on. She did find, some evidence of some impairments in the learning. He had the special education classroom. She did find some evidence about some impairment, but she talked about how the impairments that he had, for example, they were claiming that he was unable to dress himself and use the toilet. And she said, in reading the report, it doesn't say he's unable to, it only says that he won't without a lot of encouragement. And that's a different issue. What the DDD is providing services for is if somebody is substantially impaired. In other words, typically that's considered 2 standard deviations below the norm. And that means that they have to not just not want to do whatever the thing is, they have to be physically incapable of doing it. And her review of all of the records and all of the facts that were stated in all of those reports indicated that, in fact, Alex had never fallen that far below his peer group. And
did Dr. Gray, there was some debate as to whether, in my mind, as to whether she had the most recent individual education plan that she considered.
And she did not receive that. It was not submitted until after the deadline that ADES had set for Alex to submit additional documents. They did submit some additional documents past that deadline that did make it to her, and she considered them anyway. If that had made it to her before she wrote her report, then she probably would have considered that as well. Regardless, though, the board considered that, and they did find the one substantial functional limitation in the area of learning based on the testimony at the hearing and the statement that March 2018, I don't think that they actually had a copy of it in front of them, but they said the testimony had been that it would show that he was in a special ed classroom. And based on that, they found the SFL in the area of learning. But so that was all considered. And it's not that, again, it's not that Dr. Gray said, oh, these tests are insufficient, so I'm not going to consider them. And I don't think that they've proven eligibility. She went through all the facts and said nothing in here demonstrates. In fact, it demonstrates the opposite. It demonstrates that he does not have these substantial functional limitations. So this, to the extent that the department had the burden of proof, it carried it. It brought in an expert witness to analyze the facts and present an opinion. It is the ALJ's job to evaluate witness credibility and weigh the facts. It did that.
To analyze some facts.
I'm sorry, the audio is...
Judge Swan, you're cutting out. I'm not sure why. But.
I'm sorry about that. I'm sitting here in the courtroom.
You're good now. You're good now.
In any event, the expert that the department brought just looked at some of the evidence, actually selected the evidence she would look at, and excluded a large amount as unacceptable, right?
That is incorrect. She looked at everything that was in the file. She found a lot of it to not be credible or to not be particularly useful because it was 2 to 3 years old or because the person had not supported their opinion with facts. But she looked at all of the facts that were in the record and drew her own conclusion that Alex was in fact not suffering from these major life activities.
Look at any of the facts gathered in the data gathering or visits conducted pursuant to Section 565? Because I don't see any mention of it, and surely the department.
Again, there are documents in the file. Whether there are anything in the file pursuant to a particular statute, I don't, or their required periodic review, I'm really not sure, because again, that wasn't an issue. There was no issue about how these documents were gathered or whether they were done appropriately. Nobody raised that. And so
what they say, because even if they're not gathered pursuant to a statute, at least not expressly so, there should be a pattern of documents indicating that reviews are occurring on some periodic basis. And as far as I can tell, none of those reviews said this kid is a malingerer, get him out of here. They suggest that the original diagnosis was correct. So I'm wondering why all those documents that presumably are there that we have not been able to see weren't mentioned by your expert.
Okay, so my time is up, but I'll be happy to answer your question if you would like me to.
Please.
Yes.
Okay, so again, there was no issue about whether DES had properly done its periodic reviews or properly gathered documents. So they did not present a lot of evidence or testimony from the case manager, for example, about what they had done. What they did do was they put every document that was in the record, gave it to Jennifer Gray to review. She reviewed it and reached her conclusion. But that doesn't mean that those periodic reviews weren't done or that emails or memos weren't sent saying, hey, Alex, or to Mr. Croner, you know, you're going to need, we're coming up on a periodic review. You may want to submit these documents that we've been asking you for. There's no evidence in the record about whether those things took place or not, because nobody raised this as an issue at any time before this appeal. And again, those are factual issues about whether the case manager did what they were supposed to do or not. That is inappropriate to consider when nobody ever raised it and nobody ever had an opportunity to develop that record. Just like in many places, you know, the email record and the, hey, we need to gather this record information might be different from the record that contains the documents that demonstrate whether the child is eligible. So, you know, here, Alex, you know, he turned 6, they conducted a periodic review, they said, hey, he's no longer 6, and he may well have continued to meet the, quote, at-risk criteria. But when they did that review after he turned 6 and said, does he meet the criteria for children over 6, the answer was no. So they sent him the notice of intended action, they sent him the administrative decision, they indicated what the problem was, that he needed to demonstrate these SFLs, and he just never did. And so, and if anything, the record shows that every single time it had an opportunity to do so, DDD, the ALJ, its expert witness, consistently told Alex, here's what you need to get, and he consistently didn't do it. So even if we had additional information in the record, I suggest that it probably would support the idea that the case manager also did what she was supposed to do and suggested that Alex get these tests that he needed, and then he just didn't do it. So I will just close with, again, 41-1993 says that this court cannot address this issue about the case manager's obligation to assist because it wasn't raised in the petition for review to the appeals board. And that's, I submit, because of these factual issues. That the appeals board can remand to the ALJ, can take new evidence itself. And if this had been raised as an issue, there would be evidence for this court to consider.
Just so it's clear, I'm not asking these questions to evaluate the quality of the caseworker's work. I'm asking the questions to evaluate whether the legislature has implied a burden of proof. But thank you for your answer.
Thank you. Ms. Hoffmeyer, rebuttal.
Thank you. I'll be brief. You know, the government is relying very heavily, particularly now at the end, on that this is a new argument. And the argument we're talking about, which is really the quality of the documents in the file, is inextricably linked to the burden of proof. There was no burden of proof issue until the appeals board ruling. The appeals board ruling came out on February the 13th, 2019. Up until that date, everybody agreed the burden was on the department. There was no argument to be made at all before the appeals board because Alex, we certainly didn't know that the appeals board was going to suddenly reverse the burden and place it on Alex, which shines a spotlight on what is in the file. What did Alex not produce that he was meant to produce? So it's a disingenuous argument to say you should have raised this before. This was not an issue until after the appeals board, of its own accord, reversed the burden of proof. The department, up until that time, agreed that it had the burden. Then my second point is just to clarify regarding that the 2018 IEP, Jennifer Gray did have it. She got it in March of 2018, 6 months before the hearing. She mentions it in her list of documents in the report that she gave to the department. So it's very clear in the record she had that document, and she had clearly forgotten about it at the ALJ hearing. And it was an important document because it established clearly that Alex was in a self-contained classroom. She disparaged the school psychologist, saying we've got no proof he's in the self-contained classroom, which was just untrue. There was an IEP telling the ALJ and telling Jennifer Gray that he was there. Then her constant reference throughout the hearing to the Vineland and the ADES test. 1 month before the hearing, that ADES test was removed from the regulations. These are the department's own regulations. They removed the ADES test. For Jennifer Gray to repeat it again and again in front of the ALJ was dishonest. If anybody knew that those regulations have changed, that's all she does. She should have known the ADES test was no longer required. And to disparage the quality of Alex's documents based on a test that doesn't exist in the department's own regulations was not honest. And then finally, just to deal with Harvest v. Craig, because I didn't have the opportunity to talk about it, we met that standard. The appeals board relies on it, mentions that what you need to show depends inter alia on what is fair, what is convenient, who is seeking to change the status quo, and policy considerations. Those are the 4 tests mentioned in Harvest v. Craig. We went through to show that in this particular case, who changed the status quo, the department, fairness and policy considerations, you know, the initial order of presenting evidence in an ALJ hearing is the department, then the child, then the department gets rebuttal. Surely you can't put the burden on us in those situations. It's an unfair thing. What the appeals board, they then go one step further and mention this 9th Circuit case that that's been overturned by statute. And that was where the appeals board, the appeals board didn't rely on Harvest v. Craig to come up with this shifty little burden going backwards and forwards. They started with Harvest v. Craig. They then rely on a 9th Circuit case that's been overturned by statute to say that if there's some significant event, and here it's the child turning 6. So we believe we've met that standard in Harvest v. Craig. So if there are no more questions, thank you very much.
Counsel, thank you very much. We appreciate your briefing. We will take and your oral argument today. We will take the matter under advisement and we'll issue a written ruling in due course. Thank you very much. Court stands adjourned.
Thank you.
Thank you.